Good afternoon. It's Wednesday, the 15th of December. And for those of you who thought that we're on the slow glide to a long weekend and building up towards Christmas and that the news cycle will slow down, I'm very sorry to be the bearer of bad news, but more specifically, Karyn Maughan's going to be the bearer of bad news. Karyn, the news cycle's not slowing down, and we were hit in between the eyes, our collective eyes today, by a very significant judgment by the High Court ordering former President Jacob Zuma back to prison. Good afternoon, first of all, but tell us and give the viewers and our readers a high-level overview of what this judgment means.
Well, essentially, Judge Elias Matojane has made it very clear that National Commissioner of Correctional Services Arthur Fraser did not make a lawful and or rational decision when, just a few months ago, he essentially said that Jacob Zuma could be released on medical parole under the provisions of the Correctional Services Act. He said that effectively such a decision can only be made, when the Medical Parole Advisory Board, which is an independent medical parole body, finds that indeed a person or an inmate is either terminally ill or physically incapacitated to the point where they cannot look after themselves. And he says it's very clear on the evidence that those conditions did not exist in the case of Jacob Zuma, and that indeed the decision that the Arthur Fraser made was legally impermissible, given that, in fact, Jacob Zuma's medical conditions did not fit within those definitions.
So, Karyn, the gist of this is that the decision made by Arthur Fraser was unlawful. Jacob Zuma now has to go back to prison. Does the time that he spent out of jail on so-called medical parole count towards the final sentence that he has to serve?
No, it doesn't. And I think that is one of the biggest potential grounds of appeal by the Correctional Services Department. He's effectively found that, that they did not, that period should not be considered as being prison time served, which of course was one of the biggest issues that Zuma and Fraser raised in their reply to the case that was brought by the DA, HSF, and AfriForum. They essentially said this application is moot, it's academic, because Jacob Zuma would have been eligible for parole in October anyway. Matojane is saying that Jacob Zuma was not an innocent victim in all of this, that he had, outside of, in terms of his court papers, continued to attack the Constitutional Court, continued to argue, even though, the Constitutional Court found that this was not the case, that he was being detained without trial, that he had not shown himself to be a person who had stopped reoffending outside of prison, and that was a crucial ground. So I think that is going to be one of the potential bases for an appeal, but Matojane is simply rejecting it.
Karyn, let's cut to the chase. When will Jacob Zuma be reincarcerated, and do you expect an appeal to come?
I think we all know that, given Jacob Zuma's Stalingrad history of litigation, given that he will literally appeal the opening of an envelope, it is almost certain that he is going to appeal this. The Correctional Service Department has also taken a particular stance in defending Fraser's decision-making, in insisting that this correctional service legislation does allow him the kind of discretion that he argued for. So I think it's very likely that it too will appeal. And I think that this, given the implications going forward, given that medical parole has been utilized in very adverse manners in the past to protect politically connected people, I think that it is important that the courts draw a line in the sand as to who and how people would qualify for medical parole.
Karyn, you referred to Arthur Fraser's decision-making process. The judgment was quite scathing about that. The judgment is very clear that he not only did he use the wrong prescripts in law, or the wrong subsections in the relevant legislation, but the doctors that he used to justify the doctors' reports that he used to justify his decision was also deeply flawed.
Well, that's exactly the point. Essentially, Arthur Fraser tried to second guess the Medical Parole Advisory Board with reports that the board had actually considered. The judgment goes into a lot of detail, and I strongly recommend that anyone who wants to know the full history of this matter go and read it. But there was a Dr. Mapatswe who was sent by the advisory board to go and look at Jacob Zuma, and he strongly recommended that he be granted medical parole. But his report wasn't considered meaty or substantive enough by the board to justify that medical parole decision. And essentially, and we have to come back to this over and over again, because we don't have access to the full matrix of evidence that the board considered, because Jacob Zuma and the parole and the Correctional Services Department had essentially said that they would not release a lot of that information because it was confidential. But substantively, the board did not find that Jacob Zuma was terminally ill, and they did not find that he was incapacitated. And on that basis, the Judge Matojane is saying that Arthur Fraser's attempt to go here, there, and everywhere to handpick certain evidence that he believed supported his view was simply not legally and constitutionally sustainable.
Karyn, if Zuma appeals this judgment, does that stay the judgment? Does that mean essentially will he remain out of prison pending the appeal and the whole process, now the subsequent legal process being finalized?
If he does appeal, and he will appeal, as will the Correctional Services Department, it does stay the decision. And I think that at this point, we also need to emphasize that Matojane did not agree with Arthur Fraser's logic that he had intervened in this process because he feared that if Jacob Zuma died, behind bars, it could foment the kind of violence that we saw in July this year. He said the threats of riots and threats of violence were not a basis upon which to grant someone medical parole. And I think underpinning that was essentially a view that we cannot be held hostage by threats of violence when we make decisions, when medical parole authorities make decisions, that the threat of violence, the threat of unrest cannot be a basis to circumvent the law.
Karyn Maughan, the News 24's specialist legal writer, thank you so much for your insights. We will now be heading down the 478th legal route that Jacob Zuma has opened up for us. Thanks.
Thank you for having me.